Did you use how many that was very going on.
I am the Dean of the Law School on the Camden campus, and my job this evening is just to welcome you all here. So I will start with welcome to the Law School. It's so wonderful to have you all here. One of the most important things that I get to do as the co-dean of the Law School is come to events like this and see what kind of wonderful things our faculty are doing and the wonderful events that they put together. And I must say, and I'm not saying this just because Arthur and Doug are two of my favorite people, where did Doug go? Two of my favorite people in the whole wide world, but certainly the Center for Corporate Law and Governance is one of the most vibrant centers that we have here at the law school, and they're consistently doing amazing programming. One of the things that I think is really important as a state law school is that we should be a place where students from across the state, from across the country can come and become whatever kind of lawyer they want to be. So obviously we have a really vibrant public interest community here, but we also have really vibrant other communities, including our community of folks who are going into corporate law. So I find the Center for Corporate Law and Governance to be a real gift, not only to our students, but certainly to our intellectual community here as well. And also, again, this is sort of one of the best things I think that a law school can do, to not just be internally focused, but to be externally focused as well. So I also think of the center as being a gift to the future of corporate law and government practice, and also to law reform. I don't have to tell people in this room that corporations sometimes get a bad name, but they need not. And so what I like about the center is that they're really thinking about how we can have vibrant corporate cultures, that people can certainly have the corporations that they want, but those corporations also have purpose, and they have ethics, and they are part of the public good. So I'm really thrilled that we have Commissioner Peirce here today to talk to all of you. I'm a little sad because I'm not going to get to stay for her whole talk. I have to run out for another event, but I can hear some of it. And now my job is to turn it over to Stuart Alvaradi, who's going to do a second welcome to all of you. So thanks for being here.
Good afternoon, everybody. I'm Stu Alvaradi. I'm the chair of the Rutgers Center for Corporate Law and Governance in the Rutgers Law School class of 1985. I'm going to keep my remarks very brief because we're all here to hear the presentation of Commissioner Peirce. But there is a preview of an announcement I wanted to make. So I'm the newly minted general counsel of a company called Ripple. And Ripple is based in San Francisco. And what Ripple does is we connect banks and payment processes throughout the world. So remittances can be made cross-border faster, cheaper, more reliably, and more transparently than the existing legacy system, which was built before the internet, allows. And my job as general counsel is to navigate the fragmented regulatory framework that governs financial services and the fragmented regulatory framework that governs the evolving world of blockchain, which we leverage, and digital assets, also known as cryptocurrency, which we leverage, and to try to solve for them. What I'm really excited about, and this is a preview, and there'll be more to come in a couple of weeks, is Ripple is going to be partnering with Rutgers and the center, thanks to Doug Eakley, Arthur Levy, and Professor Piseva, to position Rutgers to be a thought leader in blockchain regulation and cryptocurrency regulation through education, research, and publication. So more to come. We signed a letter of intent today. Hopefully we can formally announce in a couple of weeks. But with that, I'll turn it over to Arthur.
So thank you all for being here. Thanks, Stu, for your leadership of the Center's advisory board and, of course, for Ripple's generosity. So Commissioner Hester Peirce was appointed by President Trump to the SEC and sworn in on January 11, 2018. Before that, she was a senior research fellow and director of the program on financial regulation at George Mason University in Virginia. Her research focused on the interplay between financial markets, economic growth, investor protection, and the role of regulation. Earlier, Commissioner Peirce was senior counsel at the Senate Committee on Banking, Housing, and Urban Affairs. Before that, she was counsel to SEC Commissioner Paul Atkins, and before that, she worked in her first stint at the SEC in the Division of Investment Management, where I am lucky to say that we were colleagues, oh so long ago. She earned her BA from Case Western and a JD from Yale. Let me add very quickly that Commissioner Peirce has been really a key figure in talking and writing about a number of topics, how decentralization is shaping our markets, and in particular, how to foster technological progress, innovation, and entrepreneurship, while at the same time protecting the markets and protecting investors. Notwithstanding her strong views, Commissioner Peirce is a patient listener and is always interested in what others have to say. With that, we welcome Commissioner Peirce to Rutgers.
Thank you, Arthur, and I do look forward to hearing what you all have to say. So I'm going to speak for a little bit, but then hope that we can turn this into a conversation. So as Arthur mentioned, he and I worked together many years ago in the SEC's Division of Investment Management, and it's a real honor to be back with him. I'm a big fan of Arthur, so I'm happy to be back here tonight. So I will begin with my standard disclaimer, which is that everything that I say, they're my own views, not necessarily those of the Commission or my fellow commissioners. Because Arthur is the host tonight, I thought I should start with his concise but insightful letter on his comment letter on our proposed new standard of conduct for broker-dealers who provide advice. Arthur commented that it was indeed time to align the legal standard with the expectations that investors have. In his typical scholarly fashion, Arthur pulled out the dictionary. Advise, he explained, carries with it an expectation that the advice is in the recipient's best interest, whereas convincing and persuading are not necessarily motivated by the best interest of the person being persuaded or convinced. So Arthur uses the example of a doctor as the quintessential provider of advice. So that got me thinking about my experience with those concepts, and particularly in the medical context. I try to keep my interactions with doctors as infrequent as possible. But I do remember visiting a doctor once when I was experiencing severe dizziness. And his advice to me was, stay away from the edge of the train platform. So that's sound advice, clearly not motivated by anyone's interest except my own. And it was a rather unsatisfying prescription at the time, but I did heed it, and I'm here. So it worked. Contrast that with another doctor I went to. So when I went into his office, typically on the wall you see the diploma from the nice, good medical school he went to, and in this case there was a Wikipedia entry that defined ulcer, which should have had me running out the door, but I stayed. And then next to that was a certificate for an EKG administration program course he had just taken. So not surprisingly, he convinced me that I needed an EKG. And so it seemed to me, I just had a suspicion that maybe his advice was given to me because he wanted to practice this newly acquired skill that he had just passed the course on. So I think I see Arthur's point, that there is a difference between advising on the one hand and persuading or convincing on the other, but I'm not persuaded that doctors always act in the best interest of their patients. So Arthur's letter was one of many that we've received on this topic of regulation best interest, which is one of our big rulemakings right now that's on the Commission's agenda. With the help of comments like his, we're working on a set of adopting releases, and regardless of the details, I'm hopeful that we will get to a place where investors are able to find a financial professional who works and is paid in a manner that works for them and that they understand. So now that we've started with Arthur's letter, I'm going to talk to you about some other letters. And so I want to talk primarily about enforcement this evening. And so there are two letters that will get us started on that score. I actually got a letter last week telling me that I should not be here tonight. And I didn't listen to that. I'm here. But the author of that letter thought that I would be an inappropriate lecturer because he was disappointed in what he thought I thought about a recent enforcement action of note that the Commission has taken. So then we got another letter, this was a little while ago, but I think with a similar sentiment underlying it. This letter was from a fellow, reportedly named Mellon Tusk, but now cited on the SEC's website as anonymous. He wrote to the SEC a month or so ago in response to a request for comment that we put out on earnings and quarterly earnings releases and quarterly reporting. We're trying to find out from people whether they think we need to change our quarterly reporting regime or move away from it. This commenter had some particular thoughts about my work, which I'll quote. I would also like to thank Hester Peirce for her hard work toward dismantling the SEC. Peirce is doing a splendid job of neutering SEC enforcement as much as possible and turning the SEC into the perfect tool for businesses to, quote, hunt for profits in pretty much any way that they see fit, especially those selling dreams that will come true in 3 months, maybe 6 months, definitely. So the commenter's letter, which eloquently expresses concerns some others have voiced about my approach to enforcement, suggests that maybe I need to once again take a moment to explain where I'm coming from on enforcement. I'll advise you of my position, and we'll see whether I'm able to persuade or convince you that my approach is reasonable. The hunt for profits, which is tied to meeting the needs of other people, is not a bad thing. To make profits, people have to find ways they can add value to other people's lives. And part of the SEC's mission is to facilitate capital formation, an objective that requires us to set up an effective regulatory framework, but avoid building unnecessary regulatory barriers to companies' capital-raising efforts. Capital formation is a key enabler of companies' ability to serve their customers well and thus to earn profits. If we at the SEC do our job, then people with good ideas will be able to meet the people who can give them the money to turn those ideas into products and services that make other people's lives better. A key way that we facilitate capital formation is by ensuring that companies that need money are disclosing to investors the material they need, the information they need to decide whether or not they want to invest in a particular company and whether the company will make good use of their money. We want investors to get an accurate picture of the company's long-term value. Periodically, it's important for us to revisit our regulations to think about whether they're actually achieving that goal, and that's why we issued the request for comment on the need for quarterly reporting, to which the commentator once known as Tusk responded. And that's why the Commission has undertaken a number of other initiatives to rethink disclosure obligations for public companies. Another way that we establish a regulatory framework within which our capital markets can flourish is running a strong enforcement program. A strong enforcement program requires us to draw from the admonition a judge recently gave us in a matter before her to, quote, put on our reasonableness pants. The SEC ought always to wear its reasonableness pants. And I would like to talk today about what those reasonable pants look like on a regular basis. In outlining my views on enforcement in a speech that I gave just about a year ago, I explained that the SEC is not an enforcement agency. It's rather a regulatory agency that uses enforcement as one of its tools. Appropriate enforcement of the rules that we have on our books protects investors and the integrity of our capital markets. Most enforcement recommendations that we as the Commission get are pretty straightforward legally, and they're not controversial. But there is a small subset that causes me to ask whether we're wearing our reasonableness pants. In particular, I'm not a fan of the so-called broken windows philosophy, a more is always better, punish the small violations approach to enforcement. Instead, I look at when I'm reviewing an enforcement action, I look at it and ask, are we using our enforcement resources wisely? Is this matter a matter that could have been handled by our exam program? Was there a meaningful violation? Are there other appropriate responses in lieu of an enforcement action, such as a rulemaking, interpretive guidance, or an educational bulletin for investors that would better achieve the objective we're trying to achieve? I also consider due process principles when I'm assessing enforcement actions. I think whether an enforcement action might be rulemaking by enforcement, which is something that we try to avoid. Are we pushing the bounds of the SEC's authority? Are we punishing unduly aged behavior? Or are we unduly inducing, is our case based on an undue inducement of a waiver of attorney-client privilege? I also try to think about potential unintended consequences of our actions. So are we discouraging good compliance officers from doing their jobs? Are we scaring them away from the profession? Are we imposing costs on shareholders who have already been hurt by the misconduct of executives at their companies? These are some of the common considerations that drive my approach to enforcement. But I'd like to ask in some specific examples, two specific examples, whether we were wearing our reasonable pants. So as I alluded to, reasonable pants are stitched together with due process threads. Due process concerns were front and center in my mind a few months ago, in March of this year, when we announced a settlement of 79 actions with investment advisors. This was the first fruits of our Division of Enforcement's Share Class Selection Disclosure Initiative. The initiative was a voluntary self-reporting program open to investment advisors who had, without disclosing it to their clients, had put their clients in higher cost share classes when lower cost share classes were available. Beginning in 2013, the SEC brought a number of cases that were the forerunners of this big initiative that we brought. And the underlying theory behind these enforcement actions was that the investment advisors had violated their fiduciary duty by failing to disclose to their clients that their selections of particular shares of mutual funds resulted in the advisors or their related entities or individuals being paid a fee when a lower class share without that fee was available. And so our office, this was something that we had thought about for quite some time. Our Office of Compliance, Inspections, and Examinations was also finding that there were problems in this area of share class disclosure violations, and had actually issued a risk alert to firms to warn them about this in 2016. And the Division of Enforcement finally announced their initiative on this topic in February of 2018, and then it was March 2019 when we announced the first settlements. Additional settlements could come in the future. Participating firms settled with the Commission to a cease and desist order, a censure, a payment of disgorgement, which then went back to the shareholders, and then in some cases undertakings. There was no penalty in exchange for the self-report. Even though I supported many of those settlements announced in March, I don't view this initiative as a high point in the Commission's history. The 79 distinct enforcement actions were essentially one package that were produced as a result of the initiative. Admittedly, this aggregation is helpful in the sense that it preserves staff resources and it also allows firms to sort of hide in the pack. They're announced as all together, so they're able to preserve their reputations a bit. But I think these benefits come at a cost, and the cost is to the individual consideration of these cases. The public packaging of the cases skewered important distinctions among them. Some of the firms, for example, affirmatively lied. They accepted the so-called Rule 12b-1 fees, but they didn't tell shareholders that they did, or they actually said they did not. But other firms had disclosures that we just deemed to be subpar. So maybe in broad strokes, they disclosed that there was a conflict, but they didn't disclose the precise issue at hand. I think these are lying on the one hand and then not getting the disclosure language right on the other. They're two very different violations, but they were lumped together as if they were cut from the same cloth. More generally, I think an initiative like this one, by its nature, obscures the different facts and circumstances that each participant in the initiative has, and it emphasizes the similarities. The Enforcement Division made it clear that each firm that responded to the initiative would be assessed on its own merits and demerits, but there is nevertheless a downside that comes from lumping lots of firms together in the way that we did. In other words, the initiative, in the name of efficiency, placed great tension on the due process threads of our reasonableness pants. An even more fundamental concern for me is really less about enforcement than it is what the initiative says about our regulatory program. That numerous firms in the securities industry participated in this initiative, including some really large firms, suggests to me that the SEC had fallen down on its job as a regulator. Yes, fiduciary duty belongs to the firm. In fulfilling that duty, we expect firms to exercise judgment. That's what fiduciary duty is, principles-based, so the firms have to think about how to put those principles in practice. The Commission can't spoon-feed firms the precise disclosure language that they should use. Their facts and circumstances are different. We can't tell them exactly what they need to say. And each firm, in fulfillment of its fiduciary duty, is responsible for telling clients in clear language what their conflicts are. The fiduciary duty is a firm's duty to its clients, and it's a duty that firms often brag about in order to win clients' trust. They say, we're your fiduciary, so you can trust us. That said, I think the SEC also has a duty in this case. Our duty is to be clear with registrants about our interpretation of their fiduciary duty. If we see a wide-scale departure from fiduciary duty as we interpret it, and if we see this occurring over numerous years, we owe it to firms that we regulate, and more importantly, to the investors whom we are charged with protecting, to be very clear that there's a problem. A regulator wearing its reasonableness pants tells firms that it regulates what their regulatory obligations are. So that we need to tell firms we're regulating, this is what we expect you to be doing. And when I say tell them, I don't mean to bring a few enforcement actions and expect them to hunt them down on our website and then figure out how they might apply to their particular circumstances and adjust their disclosure accordingly. We need to do more than that. I don't mean issuing a risk alert from our compliance office. That's a good thing and has been really helpful to firms. But again, if we're seeing a widespread problem that's affecting investors across the country, I think we as the commission need to issue our own guidance or promulgate our rule and put an end to the problem before it hurts investors further. Doing this is better for investors than waiting many years to bring a large enforcement initiative. It's also respectful of the due process of the firms we regulate by giving them notice of what the SEC expects from them. And yes, as you might have guessed, it's what the SEC does when it's wearing its reasonableness pants. Sadly, that's not what happened here. We spotted a problem and let it fester without a definitive reaction from the Commission for 5+ years. And the delay meant that investors went years paying fees that they might not otherwise have paid. And we know that now firms know what the disclosure formula is that we expect, so probably we won't see many of these kinds of many similar violations. But what was the cost? Investors waited years to get fees back, and regulated entities that might not have had to be part of an enforcement action now have an enforcement blemish on their record. Reasonable pants should not only be threaded with due process, but they should also fit properly. And so that brings me to another area. The SEC needs to take care of how it exercises its authority. The goal should not be for us to stretch our authority to its limits and beyond, but instead to act carefully and cautiously. So the example that I'm watching now is how the SEC reacts to the recent Supreme Court decision, Lorenzo versus Securities and Exchange Commission. Before offering my substantive thoughts, I'm going to provide you just a little background so that you know what was going on there. Mr. Lorenzo was the director of investment banking at a registered broker-dealer. His only investment banking client during the relevant time period was a company that was trying to turn waste into energy. A big chunk of the company's reported $14 million in assets was attributed to intellectual property, which Lorenzo actually knew to be worthless. The waste energy technology was apparently not ready for prime time. Shortly thereafter, Lorenzo, following his boss's direction and using his boss's words, sent 2 emails to prospective investors describing a debt offering by the company. The emails said that the assets that Lorenzo knew to be worthless were not actually worthless, but were worth a lot, and he signed the emails with his name, identified himself as Vice President Investment Banking, and he invited recipients to call him with any questions. In 2013, the SEC sued Lorenzo along with his boss and the firm. The SEC charged Lorenzo with violating Section 17A1 of the Securities Act and Section 10B of the Exchange Act and Rule 10b-5 thereunder. The SEC's administrative law judge concluded that Lorenzo had violated these provisions by sending the emails with the intent to defraud. And he ordered Lorenzo to cease and desist from violating the securities laws, barred him from the securities industry, and ordered him to pay a civil penalty of $15,000. The commission sustained the judgment. The D.C. Circuit also affirmed the commission's decision in relevant part. It rejected the commission's 10b-5b charge, but it held that by sending the emails, Lorenzo had violated 10b-5a and c, as well as Exchange Act Section 10b and Securities Act Section 17a1. So I give you all this background to set the stage for the Supreme Court case. Earlier this year, in a 6-2 decision, the court held that by sending the emails with knowledge that they contained material untruths, Lorenzo employed a device, scheme, and artifice to defraud within the meaning of Rule 10b-5a, Section 10b, and Section 17a1. Additionally, the court found that Lorenzo's conduct made him primarily liable under Rule 10b-5c for engaging in an act, practice, or course of business that operated as a fraud or deceit. So why is this case a big deal? Under Lorenzo's scheme liability, which is one type of liability, one type of fraud, anti-fraud liability, is broader than some of us believed it to be. Prior to the Lorenzo decision, I had read the provisions of the securities laws that dealt with the device, scheme, artifice to defraud, practice, or course of business to require something more than just a misstatement. I looked for some additional deceptive conduct, such as running a Ponzi scheme, misappropriating investor funds, engaging in stock manipulation, or falsifying documents. In other words, I viewed conduct that is separate from the act of making a misstatement as a necessary basis for violating these provisions. Justice Thomas' dissent in Lorenzo captures this distinction by noting that, quote, the act of knowingly disseminating a false statement at the behest of its maker without warrant does not amount to employing any device, scheme, or artifice to defraud within the meaning of Rule 10b-5a and Section 17a. Several years ago, in another Supreme Court case called Janus, the court held that only the maker of a false statement could be held primarily liable for it under Rule 10b-5b, which prohibits misstatements. In Lorenzo, the court effectively gave an alternate route to primary liability for anyone who disseminates a false statement. The majority opinion concluded, relying on the fact that Lorenzo sent the emails directly to investors, relying also on the capacity in which he acted, and his direct offer to answer investor questions, that this was not a borderline case. But the court did acknowledge that these provisions may present difficult problems of scope in borderline cases. By way of guidance on the limits of its holding, the majority offered that a mailroom clerk would not be primarily liable for disseminating misstatements. That's cold comfort. I think not even the most expansionist reader of the case would have thought that a mail clerk would be primarily liable for doing his job. There are a lot of people, though, who fall somewhere between that mail clerk on the one hand and an investment banker on the other. And so we don't know where on that scale which cases are borderline or not. The court's opinion leaves us many questions, actually. Would the result have been different if Lorenzo had repeated the boss's misstatements verbally instead of by email? If his secretary, having overheard Lorenzo deriding the value of this waste energy company, had made some grammatical changes and sent the emails out on behalf of Lorenzo, would the secretary also be primarily liable? If Lorenzo's 2 emails count as a device, scheme, artifice to defraud, act, practice, or course of business, what would not count? What, if anything, does this case say about conduct other than dissemination? Justice Thomas read the majority opinion to mean that, quote, virtually any person who assists with the making of a fraudulent misstatement will be primarily liable and thereby subject not only to SEC enforcement but private lawsuits. Justice Thomas further observes that the Lorenzo decision, quote, eviscerates the distinction as articulated in the Janus decision between primary and secondary liability and fraudulent misstatement cases. His dissent notes that the majority's opinion renders Janus a dead letter, because even though Lorenzo was not the maker of fraudulent misstatements at issue, the majority nevertheless finds primary liability under different provisions of Rule 10b-5 without any real effort to reconcile its decision with Janus. It is awfully tempting for the SEC to read and attempt to apply Lorenzo as broadly as possible. I hope, though, that we will keep in mind how unseemly it is when a regulator stretches its authority to its outer limits or beyond. Even in the wake of a Supreme Court win, restraint is the better approach. Reasonableness pants are always well-fitting and not stretched beyond decency. As we ought to do with any authority, we must exercise the provisions at issue in Lorenzo with wise discretion. We must respect the proper line between what primary and aiding and abetting liability is. Congress defined aiding and abetting liability to be the provision of, quote, substantial assistance to a securities law violator. It's important for us in the courts not to ascribe primary liability to every violation and thus write aiding and abetting right out of the statute. Instead, we have to think carefully about where that line is between primary and secondary liability. Even substantial conduct may not qualify as a primary violation. With that in mind, let's keep our reasonableness pants on and be judicious in how we exercise our authority in the wake of Lorenzo. In addition to being sewn with due process and fitting properly, reasonable pants are not cool. I hate to say it. They're not. They don't have holes in the knees the way my jeans did when I was in high school, and today's fashionable jeans also seem to have. Reasonableness pants are not an act of rebellion, as my high school pants were. or hip, as today's holy jeans are. Reasonable pants are practical and not particularly fashionable. So let me give you an example, and this time I'm going to walk out of the enforcement context. Lots of people have been asking the SEC lately to wade into a whole range of issues that are not properly within our purview. Increasingly, we're urged to tell companies how many women they have to have on their boards, to limit the ways that companies and their shareholders resolve disputes, to direct financial firms to avoid providing capital for certain industries, or to prohibit investors from getting access to products that we think they shouldn't have in their portfolios. We do not have the time and resources or the authority to do these things. We have other things to do that are not headline grabbers, but are neatly within our core mission. Practicality demands, for example, that we work on updating our transfer agent rules, modernizing our disclosure requirements for corporations, strengthening the rules that govern how financial professionals interact with investors, assessing fixed income and equity markets, developing rules for finders, and ensuring that companies and investors across the country can participate in our capital markets in ways that work for their futures. If we switch out our reasonable pants and put on a trendy pair with strategically placed holes, subsequent generations are going to look back on us, think we're crazy, and wonder why we squandered our healthy capital markets just to look cool for a moment. So I'll draw this to a close and just remind you, those of you who are academics, that you have a really important role in scrutinizing our work and identifying instances in which you think we're wearing something other than reasonableness pants. I look forward to hearing your comments and questions. Thank you.
10 or 15 minutes for questions. Do you want me to call on folks?
I can call on you. I don't know people's names.
So Don, if you want to start?
Dean Mutcherson in her welcoming remarks referred to students coming to the law school to study public interest law, some of them, and others to study corporate law. And I believe you said somewhere that corporate law is or can be public interest law, and I would love to have you expand on that concept.
I did say that. I said that at another law school, and they nearly ran me out of there, which was funny because it was University of Michigan. I'm from Ohio, and so I had said all these terrible things about Michigan with silence in the room. Then I said I thought corporate law could be public interest law, and that got people's attention. So I think that's a tribute to law students today. They think more about these philosophical issues than football, so that's a good thing. But I do think, I think each of us has unique talents and abilities and interests. And society runs well because when we're able to pursue our dreams based on those talents, abilities, and interests. And we're not all going to end up in public interest law. We're not all going to end up working in corporations. But some of us will end up working in corporations. And I don't think that people who do should feel guilty about it, because corporations exist. They exist. They're trying to make a profit for their shareholders, certainly. But in order to do that, you have to make something that people want. You have to make, or you've got to provide a service that people want. And so if we have a market system where companies that are not actually fulfilling a desire of people in society, if those companies fail and other companies come in and take those resources and use them to produce things that people want and need, that's a great system, because it makes sure that people's needs are met, and that the price system that underlies the profit making of companies is a really effective mechanism for signaling whether resources are being used well or whether they're being used badly. So, I'm reading a book now, which is a really interesting book about Russia. It's called, now I'm forgetting the name, it's Red, I forget what the name is, but the book essentially talks about how in the Soviet Union, they were trying to put in a system to mimic the price system, because the system that they had for allocating resources was failing so miserably. And so they were trying to come up with a centralized system for mimicking the price system. Why not just work with the actual price system you have? And why is that such a good system? Because everyone in the economy has a voice in that system. Because you're exercising your voice when you decide to buy one thing versus another thing. or when you decide to work at one place versus another place. So that's kind of why I think we undersell the value of corporations, that they're seeking to meet people's needs. And I think we also undersell the radical ability of capital markets to transform people's lives. And that's what gets me most excited about capital markets, because if you are really able to go into the capital markets with an idea, get that idea funded, and turn it into something that people want, we can transform not only the generation of the person, the entrepreneur who did that, but of that person's children. And the capital markets are designed to direct resources to the best idea. And so that means that it's a meritocracy. Now, obviously, it doesn't always work perfectly, but if it works well, then it can radically transform people's lives. And I think we need to be telling the next generation that this is a really powerful way to transform our society, to make sure that people in society who don't have a lot now, that the next generation will have a lot. So that's what gets me passionate about the capital markets and about encouraging people to think about where their talents are best used and not to worry about being able to have the label public interest.
Picking up on what you just said, I think a trend we could agree on over the past however long, 5 years, 10 years, is a decline in the total number of public companies from whatever it was, 5,000, 6,000, down to high twos, whatever you count them. To what do you attribute that? Are there inefficiencies in the capital markets that are causing this to happen? And what are your thoughts on, A, normatively, whether that needs to be addressed, and if you feel it does, how you go about helping?
I think there are a lot of different reasons for the number of public companies going down. So one thing people point to is the efficiency of the private markets and the amount of money that's out there in private markets, and so companies are able to raise money privately, so they don't feel the need to go public until they're much bigger than, in the past. That was really a rite of passage that you wanted to take fairly early. But now, because there's so much money sloshing around in private markets, people say, what's the point? That has a real downside, because a lot of retail investors really have a hard time accessing private markets. So from the perspective of society, I think we're better off when companies are going public earlier and everyone has access to them. I think another issue is market structure. So a company can be private and they think, oh, we really want our shareholders to be able to sell their shares, so we're going to go public so they get liquidity so they're able to sell. And then they go public and lo and behold, they can't, the market structure just doesn't work for them. Liquidity is not good, and it's really disappointing. And so other companies see that and they say, well, what's the point then of going public? So I think we can make adjustments in terms of market structure to give more flexibility so that it could work better for smaller companies. Another thing that I think is in there is litigation costs. So as soon as a company goes public, it gets lots of scrutiny, and a price drop means a shareholder lawsuit. So I think we should be open, if companies and their shareholders want it, to put in arbitration clauses instead of so that there's a way out of shareholder litigation like that. And then I think there's also just that we have a lot of rules. So it's expensive to be a public company, and you have to make that calculus whether it's worth it. And it's one thing if the rules that we impose are saying, okay, we're trying to get material information to investors. If you're a public company, that's what you need to do. But it's another when we're putting all kinds of random requirements on companies that have no real value to the investors. So for example, Sarbanes-Oxley put in a requirement that companies get their internal controls audited by an auditor who's registered with this new, well, it's not new anymore, but with the Public Company Accounting Oversight Board. It's a very costly requirement, especially tough for companies that are non-revenue companies who have to go to their investors and say, hey, you want to know what we spent your money on? We spent your money on the auditor over there. And it's ridiculous because their investors want them to spend money on developing the drug that's going to make the company money. So anyway, I think there are a lot of things that we could do on that front, and we're trying to do. I mean, this is something that Chairman Clayton at the SEC has really come into the agency saying we need to think about this, we need to think about what we can do on a number of fronts to make it more attractive to be public and perhaps to give retail investors more access to private markets as well. So there are a number of things we can do, but I don't think there's one silver bullet.
Just out of curiosity, is the SEC internally discussing in a very unofficial way what's going on with low voting structures at the IPO stage? Because 10 years ago, this was a sort of a trend in the past that media companies tended to go public with super voting and low voting structures. But nowadays, I mean, related students in class bring up that, IPO, et cetera. So the SEC got burned once already with the DC Circuit and DC on the table with trying to pass a law that would limit to some extent, and now this law, this is a regulation because of the stock exchange that adopted. But it's something that is going to happen in your view at a regulatory sphere or at the by either the SEC or the stock exchange.
So this is a phenomenon where a lot of companies that are going public are putting in dual class structures, which allows certain shareholders to basically retain the control of the company, which you can understand why a founder of a company might want to build in control for herself and her co-founders, but you can also understand why shareholders might not love the fact that a 22-year-old or 25-year-old founder has arranged so that she can have voting control for the rest of her life, because that looks like a really long time potentially. So, there are two sides of that issue. I don't view it as something that is in the SEC's purview to address, other than to say you better tell people what your structure is and how, that's pretty important information for people to have. There's a lot of pressure from some big shareholders not to have that kind of a structure. So I sort of think it's something that, but at the same time, there's a lot of pressure, there's a lot of attraction for companies going public to have it. So it's sort of the market is going to have to figure that out in each individual instance. You're right that exchanges can play a role if they think it's important not to have that kind of structure, then they can build that, or to have that kind of structure, they can build that into the list. But I just don't think it's my job.
Right.
There's a question over here.
Oh, actually, yeah.
Too, so we'll get back to you.
Yeah.
Go to you first.
If you don't mind, one is two things that you were mentioning. One is the Sarbanes-Oxley requirements applicable to small reporting companies like SOX 404B and so on. Any thought about exempting small reporting companies out of some of those more onerous requirements? And secondly, implicitly before you were saying that the Private Securities Litigation Reform Act years ago didn't do what it was supposed to do. Is there any sort of legislatively expanding that?
On the first point, I think about exempting smaller reporting companies all the time from those kind of requirements. And so, I think we need to take into account costs and benefits and not just look at what the costs and benefits are of the big companies, but we need to think about smaller companies or companies that might somehow otherwise be distinguished, for example, non-revenue companies, low revenue companies. So yeah, I think that's something that we need to think about it. And we do try to do a fair amount of tailoring. It doesn't always go as far as I'd like to see it go. And on the second point, which now you have to remind me what it was.
The Private Securities Litigation Reform Act.
Oh, litigation. So whether or not that's a tough issue to get movement in Congress on, and it's above my pay grade. So whether or not that will happen, I don't know. But I think there is a lot of interest in many corners in moving to arbitration, and I don't again see why it's our purview to stand in the way of that. If people have reasons that they can explain to me why we have a rule there, I'm willing to hear them. But so far, I haven't heard one that is convincing to me, but again, I'm open to hearing that.
So, from my perspective, one of the larger attacks on pools of capital in the last decade, just over the 2008 financial crisis, one contributing factor to that was the sale and packaging of CDO squared, those kinds of securities. So with American debt on the rise again, with school debt at epic proportions, do you see any role for the SEC to protect against a potential 2008 type scenario?
Well, I think we certainly do have a role in making sure. One of the things that I think was problematic in 2008 is that people really didn't have good visibility into what was in, the quality of the loans underlying some of these pools. And so that's certainly within our purview to get people better information on that. I think we've taken some steps in that regard, and I think there's probably more that we could do. But really, other than the information provision role, I don't think there's a huge amount that we can do on that particular issue. More generally, I think we need to take a step back, because now the crisis was 2007 to 2009, then it took not long enough, in my opinion, to put together this massive response, Dodd-Frank, and now that we have it mostly in place, we're still working on implementing pieces of it, because it was massive and we got lots of rulemaking requirements under it. But now that it's been in place for a number of years, I think we need to look back and say, before there's a crisis, to say, did we get it right? And I'm not sure that if we did that, we would conclude that everything we did would help prevent another financial crisis. I think we might find that some of the rules that we put in place interact in a way that could actually aggravate a future crisis. And some of these things are liquidity requirements. Sound like a great idea, but you have to think about, in a crisis, people want liquidity naturally. Like inherently, you want to have your assets as liquid as possible. But when you then put on top of that a regulatory requirement that you have to have a certain amount of your assets and liquid assets, then you've got everyone running to grab the same assets, and that can really lead to some very bad consequences. And then as another example, I think we need to think about, in the derivative space, we've created these clearinghouses, which are sort of central points, and we did it because we thought clearinghouses are safer places for these derivatives to be, for your counterparty to be a safe clearinghouse. But now the clearinghouses are really massive in our financial system, so we need to make sure that that they're properly safe and regulated. So that's another area that I think we need to keep our eyes on.
So listening to your remarks, the SEC, we can use rulemaking and educational guidance to give guidance to market participants. We use enforcement actions to show market participants what bad looks like. What about the use of an action letter to show market participants what good looks like? What's the SEC's, what's your views in terms of the balance between enforcement actions and no action letters?
So a no action letter is a staff, typically, it can be commissioned, but typically it's a staff letter that someone will write in and say, hey, here's what I'm trying to do, and the staff will write back and say, all right, if you do this, bearing in mind these conditions, having these conditions in place, then we will not recommend an enforcement action to the commission. And so it would be very unlikely that then if there were such a letter in place that then the staff would go to the commission and say, hey, we're going to recommend an enforcement action, though the letter does say we can change our mind at any time we want. So maybe not the strongest thing to rely on, but as it turns out, no action letters have become really powerful changers of behavior. And so you can have one no action letter directed to one participant in the market, and you can get an entire change in the whole industry based on that one letter. And that's something that I worry about, because I think, again, if the whole industry needs this relief, we should be doing it as a rule. But in individual instances, I think no action letters can be really useful, because our rule book is so huge, and there's so many facts and circumstances that we could not imagine when we're writing a rule. And so a no action letter can be a really effective way for someone to come in and say, hey, here's a specific circumstance, we think we shouldn't be covered by this rule, will you give us some comfort that we're not? And I think that's a really valuable thing. We had an interesting, so I haven't talked about crypto at all, but we had an interesting no action letter that was released recently in the crypto space. And it's something that people in the crypto space have been asking for guidance. And I've encouraged people to come in, hey, if you've got a particular set of facts and circumstances, come to the SEC, get the staff to consider issuing a no action letter, because it could be really useful to you, and then kind of give some pointers to other people on how the SEC staff is thinking about issues in this space. And so, sure enough, the staff issued a no action letter a couple weeks ago, and it was for a chartered debt company that was essentially going to build this token network, basically so that people could, at the spur of the moment, hop on a charter and not worry about having to wait because it's expensive, I guess, I've never done it, but I assume it's expensive, so you don't have to wait for the bank wires to clear and all that. You can use your token that you prepaid and hop on the plane and you're on your way. So fine, that's great. I knew that wasn't a security, and I'm pretty sure everyone else knew that wasn't a security. So I think in instances like that, a no action letter can actually be harmful, because then people think, wait a minute, this is the example I use, like, do you have to come in for Chuck E. Cheese tokens? Does Chuck E. Cheese need to come in and get pre-clearance that their tokens are not securities? I mean, surely that can't be the case. But in any event, I appreciate the staff's motivation in issuing the letter, because what they're trying to say is, hey, there are things that just because it's a token doesn't mean we're going to jump all over it and say it's a security. But I think it sends a little bit of a mixed message.
So before we stop, let me just say quickly, we have a reception following Commissioner Peirce's lecture on the 4th floor of this building in our faculty lounge. But I think our time is up, so I'd like to thank you for coming. And conversation upstairs.
Yes, I don't know if I formally introduced myself. I'm Rick Madursky, Tom Leahy's co-editor. So I have Fiduciary Duty. So I haven't gotten a class yet. I met with Professor Levy and Russell at 3 o'clock. So I talked to her about 45 minutes about concern and scholarship participation. We have the participation. So yeah, I'm going to go to faculty to see what responses are from the faculty. I think that is one who's like presenting it at the meeting. I don't know. Yeah, I don't know how. I have no idea. But I'll see you upstairs. I'll see you tomorrow. Yes, hopefully. Yeah, I think their view is having a big role. Hey, how are you? Travis Laster. Good to see you. How are you? Absolutely. Thanks for remembering. You. Great.
I mean, she does a lot of other movement, which is general counsel, and has been to state.
Well, they're not, but they're
tour manager.